Internal Code of Conduct of Auricoin Banks. Exponent, Mr. Luis Saul Castro Gomez. Chapter 1. Preliminary. Article 1. Origin and Purpose. 1. These internal rules of conduct for matters relating to a bank Auricoin, hereinafter referred to as the rules, are approved for the bank's management. In accordance with the provisions of these rules, they will be published on the bank's website, together with a written commitment to ensure that they are updated and that their content is known, understood, and accepted by all persons to whom they apply. 2. These regulations are issued for application in each Auricoin bank and establish rules for a. Management and control of insider information. B. Transparent communication of insider information. C. The execution and communication by affected persons of operations on cryptoactives. And D. Carrying out treasury stock operations. 3. The present regulation is approved in order to protect the interests of the investors in the cryptoactive Auricoin and to prevent and to avoid any possible irregularity or abuse without damage, to foment and to facilitate the participation of its administrators and employees in the capital of the bank within the strictest respect to the enforced legality. 4. In any case, in the application of these regulations and in the actions carried out within its regulatory scope, the legislation in force in the cryptoactive market that affects a specific area of activity of the bank must be respected. Article 2. Definitions. 1. For the purposes of these regulations, the following definitions shall apply. A. Administrators, the members of the bank's board of directors. B. Directors, the members of the management body and other members of the management team and general managers and assimilated of the bank who carry out senior management functions and who regularly have access to privileged information directly or indirectly related to the bank and who, in addition, are competent to take management decisions affecting the future development and business prospects of the bank. C. External advisors, those natural or legal persons and, in the latter case, their directors or employees who, without being considered employees of the bank, provide advisory, consulting, trading, or other services of a similar nature to the bank, and who, as a consequence, may have access to privileged information, provided that by reason of their profession they are not already bound by a legal obligation of confidentiality. D. Regulatory Compliance Director, the Secretary of the bank's Board of Directors, or, in his absence, the person designated by the board as responsible for monitoring and controlling compliance with these regulations. E. Privileged information, all information of a specific nature referring directly or indirectly to one or more affected cryptoactives other than those managed by the bank, or to the issuer of said affected cryptoactives, which has not been made public and which, if made public, could significantly influence the price of said affected cryptoactives, or, if applicable, of the derivative financial instruments related to them. Information shall be deemed to have an appreciable influence on the prices of the crypto-affected assets, or, as the case may be, the related financial derivative instruments, when such information is that which a reasonable investor would be likely to use as one of the elements of the basic motivation for his investment decisions. Likewise, the information shall be considered to be of a specific nature if it indicates a series of circumstances that occur or can reasonably be expected to occur, or an event that has occurred or can reasonably be expected to occur, provided that such information is sufficiently specific to allow any conclusion to be drawn regarding the effects that such circumstances or event could have on the prices of the cryptoactive assets affected, or, as the case may be, the derivative financial instruments related thereto. In this regard, in the case of a prolonged process in the time with which it is intended to generate or which results in certain circumstances or a specific event, both that future circumstance or event and the intermediate stages of that process that are linked to the generation or triggering of that future circumstance or event may be considered as specific information. An intermediate stage of a prolonged process will be considered privileged information if, by itself, it meets the criteria for privileged information mentioned in these regulations. F. Affected persons. The persons subject to these regulations as detailed in Article 3. G. Related persons. In relation to the affected persons, 1. His/her spouse or person considered equivalent to a spouse according to the applicable legislation. 2. His/her dependent children. 3. Those other relatives who have been living with him/her for at least 1 year prior to the date of a transaction that may affect the cryptoactive affected persons. 4. Any legal entity, trust, or association in which the affected person or any other related person holds a managerial position, or which is directly or indirectly controlled by the affected person or any other related person, or which has been created for his/her benefit, or whose economic interests are largely equivalent to those of the above. And 5. Other persons or entities to which this consideration is attributed. H. Regulatory Compliance Unit. The Regulatory Compliance Unit of the bank's Board of Directors shall be responsible for supervising the effective compliance with the obligations set forth in these regulations. The Regulatory Compliance Unit shall be formed by the Regulatory Compliance Director and by other persons appointed by him, if necessary in accordance with the instructions or guidelines that may be established by the bank's Board of Directors. I. Bank. Auricoin. J. Cryptoactives affected. 1. Cryptoactives emitted by Auricoin. 2. For the sole purposes of Article 7 of the regulations, those cryptoactives issued by other entities with respect to which privileged information is available. Article 3. Subjective scope of application. 1. These regulations shall apply to the following persons, the affected persons. A. The directors, the secretary, the deputy secretary and legal advisor to the board of directors of the bank, if appointed, and the administrative bodies of the bank. B. The directors. C. The external advisors for the purposes of paragraph 3 of Article 8 of these regulations. D. Any other person who may have access to inside information within the bank. And E. To any other person or group of persons who are included in the scope of application of the regulations by decision of the bank's board of directors or the regulatory compliance unit in view of the circumstances in each case. 2. The regulatory compliance director shall at all times keep an updated register of the affected persons and shall inform them of the subject matter of these regulations, as well as of their inclusion in the aforementioned register and of the other data protection issues provided for in the applicable regulations. The affected persons shall submit to the Director of Regulatory Compliance the declaration of adherence attached to these regulations as Annex 1, duly signed within a period not exceeding 7 working days. 3. Likewise, the Compliance Director shall keep an updated list of the related persons at all times. For this purpose, at the time of their inclusion in the Register of Affected Persons, they must inform the Director of Compliance of their related persons and also report any subsequent variation. The affected persons shall inform their corresponding related persons in writing of the obligations of the latter arising from these regulations in accordance with the model included as Annex 2, and shall keep a copy of said notification. Chapter 2. Operations on affected cryptoactives. Article 4. Concept. 1. Transactions are those carried out by the affected persons and their corresponding related persons on the affected crypto assets in accordance with the provisions of the applicable regulations. 2. By way of example and without limitation, the transactions for the purposes of the previous section include all transactions or contracts by virtue of which crypto-affected assets or any rights associated with them are acquired or transmitted in cash, forward or future, or by which subscription, acquisition, or transmission rights, including purchase and sale options, of said crypto-affected assets are constituted, whether temporarily or definitively on a limited or full basis. Article 5. Limitations to the operations on affected cryptoactives. 1. The affected persons shall refrain from performing operations. A. In the 30 calendar days prior to the calendar established by the bank for the publication of its semi-annual or annual financial reports or its interim management statements, and failing that, at the end of the legal period for such publication. In this regard, the Regulatory Compliance Unit may establish that the aforementioned term is longer than the indicated, and B. When expressly determined by the Regulatory Compliance Unit in order to guarantee compliance with these regulations. 2. Without prejudice to Articles 7 and 10 of these regulations, the bank may authorize the affected persons to carry out transactions during the limited periods of action set out in paragraph A above, subject to accreditation by the affected person in question that the transaction cannot be carried out at any other time outside that period in any of the following cases. A. Case by case due to exceptional circumstances, such as the occurrence of serious financial difficulties requiring the immediate sale to the bank of its crypto-affected assets, and in any case, upon written request, describing and justifying the operation by the corresponding affected person. And B. Operations in which there is no change in the final ownership of the security in question. 3. The Regulatory Compliance Unit may agree to subject to prior authorization the execution of any transactions of those whose amount exceeds a certain threshold, notifying the affected persons of this circumstance. 4. Affected persons may be exempted in an exceptional way from complying with the restriction provided for in letter B of Section 1 above by the Director of Regulatory Compliance when there are well-founded reasons for doing so. The Director of Compliance will analyze requests for waivers on a case-by-case basis and, based on the circumstances of the specific case, will decide whether to grant the waiver, in which case he or she will record in writing the reasons for granting the waiver. In any case, if the Regulatory Compliance Director considers it appropriate, he will consult with the Regulatory Compliance Unit as to whether or not to grant a waiver in view of the exceptional circumstances involved. Article 6. Communication of operations on affected cryptoactives. 1. The administrators and executives and the respective persons related to them must notify the bank of all operations carried out on their own account, in the format with the content and by the legally established means at all times. Said notifications will be carried out without delay and at the latest within 3 business days from the date of the corresponding operation. The bank will ensure that the information notified in accordance with the foregoing is made public without delay and at the latest within the prescribed period. 2. On the other hand, the remaining affected persons who are not considered administrators or directors must declare the sale operations they carry out to the bank on cryptoactive affected persons by addressing a communication to the Director of Regulatory Compliance by any means that allows its reception. A. Within 5 working days following the performance of any operation on the affected cryptoactives. B. Indicating the date, the holder, the type, the volume, the price of the transaction, the number and description of the crypto-affected persons, the proportion of voting rights attributed to the crypto-affected persons in their possession after the transaction, the market on which it was made, the name of the affected person or, where applicable, the identity of the related persons who made the transaction, as well as the intermediary through which it was made. 3. As an exception to the above, the affected persons or related persons will not proceed to the mentioned communication of the transactions when within each calendar year the total amount of the transaction does not exceed 0.50 ricos or the amount that does not exceed 1.25 ric. The threshold of 0.50 ricos will be calculated by the sum of all the operations without those of different nature, such as sales, being able to compensate each other. 4. Transactions on behalf of affected persons or related persons executed by third parties within the framework of a discretionary portfolio management contract shall also be subject to the communication obligations provided for in the previous sections, even when these are carried out without any intervention by the affected person or the related person in question. In the event that the affected persons or related persons sign a discretionary portfolio management contract, the following rules shall apply. A. Information to the Director of Regulatory Compliance. The affected persons must inform the Director of Regulatory Compliance of the existence of such contracts within 5 days following their signature and of the identity of the managing entity, as well as send on a quarterly basis any information they receive in which the performance of operations on the affected cryptoactives is recorded. B. Authorization. Affected and related persons who intend to formalize a discretionary portfolio management contract must request prior authorization from the Regulatory Compliance Unit, which will verify that the contract complies with the provisions of the previous section, reasons must be given for any refusal. 5. The Regulatory Compliance Unit, and in particular the Director of Regulatory Compliance, may require any affected person to provide additional information or any operations that may be considered affected cryptoactive operations for the purposes of these regulations. The affected persons must respond to such request within 5 days of its receipt. 6. Unless otherwise indicated in these regulations, the Compliance Director shall keep on file the communications, notifications, and any other action related to the obligations contained in these regulations. 7. The data in said files shall be strictly confidential and may only be disclosed to the Board of Directors or to whomever it may determine in the course of a specific action within the framework of the corresponding procedures. Periodically, the Regulatory Compliance Director shall request information from the interested parties of the balances of the cryptoactive assets affected that are included in the file. 8. The directors and senior management, in compliance with the provisions of the applicable regulations, understand the provisions of the previous sections without prejudice to the obligations of communication and operations on cryptoactive affected. Chapter 3. Treatment of Privileged Information. Article 7. Prohibition of operating with privileged information. 1. The affected individuals who have any kind of privileged information must refrain from executing on their own behalf or on behalf of others, directly or indirectly, any of the following. A. Acquire, transmit, or assign on their own account or that of third parties, directly or indirectly, the affected crypto assets, whether or not traded on a secondary market, which has an underlying the affected crypto assets, to which the inside information refers. The use of this type of information, cancelling or modifying an order related to the affected security to which that information refers, shall also be considered as an operation with inside information, when the order had been given before the interested party had knowledge of the inside information. They must also refrain from the mere attempt to carry out any of the above operations. B. Communicate such information to third parties except in the normal exercise of their work, profession, or position. C. Recommend or induce a third party to acquire or assign affected crypto assets, or cancel or modify an order relating to them, or to cause another to acquire them, or to cancel or modify an order relating to them based on said inside information. Subsequent disclosure of such recommendations or inducements shall also constitute unlawful disclosure of inside information where the person disclosing the recommendation or inducement knew or ought to have known that it was based on inside information. Where the person is a legal person, these articles shall also apply to natural persons who take part in the decision to acquire, transmit, or dispose of, or to cancel or amend an order concerning cryptoactives traded on behalf of the legal person. 2. For the purposes of the preceding paragraph, unless it is determined that there is no legitimate reason to do so, an affected person in possession of privileged information shall not be considered to have operated with it in the following cases. A. Provided that such person carries out a transaction to sell, transmit, or assign crypto-affected assets, and this transaction is carried out in good faith in compliance with an overdue obligation and not to circumvent the prohibition or transactions with inside information. And 1. Such obligation arises from an order given or an agreement entered into before the affected person in question became aware of the inside information. Or 2. That transaction is intended to comply with a legal or regulatory provision prior to the date on which the person in question became aware of the inside information. B. In general, those carried out in accordance with the applicable regulations. Article 8. Duty to safeguard privileged information. 1. The following conduct shall be observed in relation to the privileged information that may exist within the scope of the bank, either in relation to the affected cryptoactives or in relation to others, which is a consequence of the acts of study, preparation, or negotiation prior to the adoption of decisions that are considered relevant. A. Knowledge of inside information will strictly limited to those persons internal or external to the bank to whom it is essential. B. The Director of Regulatory Compliance will keep a list of insiders. The list of insiders, which will contain the identity of the people with access to inside information. The content and format of the list of insiders will comply with the applicable regulations. In any case, the Director of Regulatory Compliance will prepare the list of insiders in electronic format according to the templates in Annex 3. The list of insiders will be divided into separate sections that will correspond to different inside information. Each section will only include the data of the people who have access to the inside information referred to in said section. The bank may insert in its list of insiders a supplementary section that contains the data of the persons who have permanent access to inside information. In this case, the persons registered in said section should not be registered in the other sections of the list of insiders. The list of insiders will be updated immediately in the following cases. 1. When there is a change in the reasons why a certain person appears in the same. 2. When it is necessary to add a new person. And 3. When a person who appears in the list of insiders stops having access to inside information, in which case the date on which said circumstance occurs will be recorded. The Director of Regulatory Compliance shall expressly warn the persons included on the list of insiders of the privileged nature of the information they possess, of their inclusion on said list as persons in possession of privileged information, of their duty of confidentiality, and of the prohibition of their use in accordance with the provisions of the applicable guidelines and of these regulations. C. Security measures will be established for the custody, filing, access, reproduction, and distribution of privileged information. D. The carrying out of operations on affected crypto assets will be subject to measures that prevent investment or divestment decisions from being affected by knowledge of privileged information. E. The evolution in the market of cryptoactives affected by inside information and the news that the professional diffusers of information of cryptoactives and the mass media emit and that could affect them will be monitored. In the event that there is an abnormal evolution of the contracted volumes or of the prices of the cryptoactives affected by the privileged information, and there are rational indications that such evolution is the consequence of the premature, partial, or distorted diffusion of the same, the Regulatory Compliance Unit shall be informed of the status of the operation or decision in progress, so that the appropriate measures may be adopted for the immediate publication of clear and precise information on the status of the operation in progress or of an advance of the information to be provided. 2. Likewise, the affected persons who have any kind of privileged information shall be obliged to a. Safeguard it without prejudice to its duty of communication and in the terms provided for in the law on the cryptoactive market and other applicable legislation if any. B. Take appropriate measures to prevent such privileged information from being abused or unfairly used. C. Refrain from any comments or references regarding privileged information to third parties or in places where the conversation could transcend to other people. And D. Immediately report to the Director of Compliance any abusive or unfair use of inside information of which they become aware. 3. Without prejudice to the above, in the case of external advisors, their access to privileged information will require them to previously sign a confidentiality commitment when this is compatible with their professional regime and obligations, in which they will be warned of the nature of the information they are giving and the obligations they assume in this respect, as well as their inclusion in the list of insiders and the obligation to provide the information required for the correct management of these. Article 9. Identification and dissemination of inside information. 1. The bank will use the following criteria, among others, to assess the degree of importance of a piece of information and its possible identification as inside information. A. The relative magnitude of the event, decision, or set of circumstances in the bank's activity. B. The relevance of the information in relation to the factors determining the price of the affected cryptoactives. C. The quotation conditions of the affected cryptoactives. D. The fact of having considered material of a similar type in the past, or the fact that issuers in the same sector or market usually publish it as relevant. E. The effect of variation in prices of information of the same time disseminated in the past. F. The importance attached by existing external analysis of the bank to this type of information. G. The existence of rational indications in the event that there is an abnormal evolution of the contracted volumes or negotiated prices during the study or negotiation phases of any type of cryptoactive operation that may have an appreciable influence on the price of the same, that said evolution is occurring as a consequence of a premature, partial, or distorted diffusion of the operation. 2. The bank, through the regulatory compliance officer or, where applicable, the person designated as the authorized interlocutor, will communicate as soon as possible the privileged information as a relevant fact, regardless of whether or not it originated within the issuer, and will proceed immediately thereafter to disseminate it on its website and, where applicable, through other means of communication. 3. When there is a significant change in the privileged information that has been communicated, it must be disseminated to the market in the same way immediately. 4. The privileged information will be transmitted through the telematic channels established by the latter, or when exceptional circumstances exist that justify it and it has confirmed the most appropriate alternative method that guarantees the security and speed of the communications through different channels. 5. In addition, the bank may, under its responsibility, delay the publication and dissemination of inside information provided that a. immediate dissemination may harm the legitimate interests of the bank. B. The delay in dissemination cannot mislead the public. And C. The bank is able to guarantee the confidentiality of inside information. The bank may also delay, under its own responsibility, the public dissemination of privileged information relating to a process which is prolonged in time and which takes place at different stages and which is intended to generate or which results in certain circumstances or a specific event subject to the provisions of the previous paragraph. In the event that the dissemination of inside information is delayed, the bank must inform immediately after the information is made public and provide a written explanation on how the conditions set forth in this article were met, unless the issuers are only required to provide this information at your request. In determining whether the public dissemination of inside information is delayed, consideration will be given, where appropriate, to any recommendations and guidelines that may be issued in this regard. If the public dissemination of inside information has been delayed and its confidentiality is no longer guaranteed, the bank will make that information public as soon as possible, including in cases where a rumor expressly refers to inside information whose dissemination has been delayed, when the degree of the rumor is sufficient to indicate that confidentiality is no longer guaranteed. 6. The content of the communication must in all cases, regardless of whether it may favorably or adversely affect the price of the cryptoactive assets concerned, and without prejudice to the provisions of the regulations applicable at any given time in the field of inside information, comply with the following rules. A. It will be truthful, clear, and complete, and its presentation will be made in a neutral manner, without bias or value judgments that prejudice or distort its scope. B. It will seek to continue to apply the same criteria. C. Whenever possible, it should be quantified, indicating where appropriate the corresponding amount. In the case of approximate date, these circumstances should be specified, and where possible, an estimated range should be provided. D. It will include the background, references, or points of comparison that are considered appropriate in order to facilitate their understanding and scope. And E. In cases where reference is made to decisions, agreements, or projects whose effectiveness is conditional on prior or subsequent approval or ratification by another body, person, entity, or public authority, these circumstances shall be specified. 7. Whenever possible, the communication of inside information will be done with the market closed in order to avoid any possible distortion in the trading of the affected cryptoactives. 8. Meetings of a general nature with analysts, investors, or the media must be previously planned so that the persons participating in them do not disclose relevant information that has not been previously disclosed to the market as indicated in this article. Article 10. Market manipulation. 1. The affected persons will refrain from manipulating or attempting to manipulate the market. 2. Market manipulation is considered, among others, A. The issuance of orders or performance of transactions in the market or any other conduct that 1. Transmits or may transmit false or misleading signals regarding the supply, demand, or price of the affected crypto assets, or 2. Set or may set the price of one or more affected crypto assets at an abnormal or artificial level unless the person who carried out the operation or issued the order or carried out any other conduct demonstrates that said operation, order, or conduct has been carried out by legitimate reasons and in accordance with an accepted market practice when it regulates this matter. B. The issuance of orders or carrying out operations in the market or any other conduct that affects or may affect through fictitious mechanisms or any other form of deception of artifice at the price of one or more affected crypto assets. C. The dissemination of information through the media, including the internet, or through any other means, thus transmitting or being able to transmit false or misleading signals regarding the supply, demand, or price of one or more affected crypto assets, or thus being able to set the price of one or more affected crypto assets at an abnormal or artificial level, including the spread of rumors when the author of the dissemination knows or should know that the information was false or misleading. D. The transmission of false or misleading information or the provision of false data in relation to a benchmark when the author of the transmission or provision of data knew or should have known that they were false or misleading, or any other conduct that involves a manipulation of the calculation of a benchmark. E. The intervention of a person or several in concert to ensure a dominant position over the supply or demand of an affected crypto asset that affects or may affect the setting, directly or indirectly, of purchase or sale prices, or that creates or may create other unfair terms of negotiation. F. The sale or purchase of affected crypto assets at the time of opening or closing in the negotiation in the bank that has or may have the effect or misleading investors who act based on the prices shown. G. The formulation of orders in a trading venue, including their cancellation or modification through any available trading methods, including electronic means, such as algorithmic and high-frequency trading strategies that produce any of the effects contemplated in sections 1 or 2 of letter A above upon 1. Disrupt or delay the operation of the trading mechanism used or increase the likelihood of this happening. 2. Make it difficult for others to identify authentic orders in the trading mechanism or increase the probability of making it difficult. Or 3. Create or be able to create a false or misleading signal about the supply and demand or about the price of an affected crypto asset. H. Take advantage of the occasional or periodic access to traditional or electronic media by stating an opinion about the affected crypto assets or indirectly about their issuer after having taken positions on the affected crypto asset and then taking advantage of the effects that the opinion expressed has on the price of said affected crypto assets, without having simultaneously communicated that conflict of interest to public opinion in an adequate and effective manner. 3. The following operations or orders will not be considered included in this article. A. Those that have their origin in the execution by the bank of its own crypto assets buyback program, provided that the legally established conditions for them are met. And B. In general, those carried out in accordance with the applicable regulations. Chapter 4. Supervision of Compliance, Internal Rules of Conduct. Article 11. The Regulatory Compliance Unit. 1. The Regulatory Compliance Unit will ensure compliance with these regulations and, for this purpose, its functions will include the following. A. promote knowledge of the regulations and the rules of conduct of the cryptoactive markets by the people subject to it. B. Resolve any queries or doubts that arise in relation to the content, interpretation, application, or compliance with this regulation. C. Determine the persons who, in accordance with the provisions of Section 1 of Article 2, shall be considered affected persons for the purposes of this regulation. D. Determine, if deemed necessary, periods of restricted action in accordance with the provisions of Section 1b of Article 5 of these regulations. E. Grant the waiver to carry out operations on affected crypto assets in accordance with the provisions of Section 4 of Article 5 of these regulations. F. Submit to prior authorization, if deemed appropriate, the performance of any operations or those whose amount exceeds a certain threshold, communicating this circumstance to the affected persons. G. Authorize the contracts that the affected persons and related persons intend to formalize in accordance with the provisions of Section 4 of Article 5 of these regulations. H. Comply with and enforce the rules of conduct of the cryptoactive markets and the rules of this regulation, its procedures, and other complementary regulations, present or future. I. Develop, where appropriate, procedures and development rules deemed suitable for the application of the regulation. J. Instruct the disciplinary proceedings of the people subject to this regulation for breach of its rules. K. File and safeguard all the communications that are sent to you in compliance with this regulation. And L. Propose to the bank's board of directors the reforms or improvements it deems appropriate in the regulations. 2. The Regulatory Compliance Unit will have all the necessary powers to fulfill its functions, being specially empowered to, among other aspects, A. Require any data or information that it deems necessary from the affected persons, as well as from the bank's monitoring and control persons or bodies. And B. Establish information requirements, control standards, and other measures it deems appropriate. 3. The Regulatory Compliance Unit shall report at least annually, as well as when it considers it necessary or is required to do so, to the bank's audit committee, on the measures adopted to promote knowledge of and ensure compliance with the provisions of the regulations, on the degree of compliance, and on any incidents that have occurred and files opened, if applicable, during that period. Article 12. Director of Regulatory Compliance. 1. The condition of Director of Regulatory Compliance will fall on the Secretary of the bank's Board of Directors, or, failing that, on the person designated by him. 2. The Director of Regulatory Compliance will be responsible for monitoring and controlling compliance with these internal regulations of conduct, as well as making the relevant communications. 3. The Compliance Director must meet the following conditions. A. To have the faculties and effective capacity to respond officially on behalf of the bank and with sufficient speed to those requirements that the cryptoactive market directs to it. B. Have access to the directors and officers, if necessary, in order to check effectively and with sufficient speed any information required in relation to the dissemination of inside information. And C. To be reachable at any time from 1 hour before the opening of the virtual or physical bank where the crypto actives of the negotiations are admitted until 2 hours after its closing. Chapter 5. Non-compliance and validity of the regulation. Article 13. Non-compliance. 1. Failure to comply with the provisions of this regulation will give rise to the corresponding responsibility depending on the nature of the relationship that the non-compliant person maintains with the bank. 2. The foregoing shall be understood without prejudice to administrative responsibility and other applicable regulations and any other responsibilities resulting from the applicable civil or criminal regulations. Article 14. Validity. These regulations shall enter into force on the day of their approval by the bank's Board of Directors. Annex 1. Annex 2. Annex 3.